We've got a little technical glitch up here, so whenever someone is presenting their bill from the floor out here, we'll have you give you a hand mic, because it's, you know, our new secretary up here is...
Been spilling water on me. Sorry, sir.
Yeah.
Didn't take me 2 days.
Okay. Representative Hawkins, would you open us with prayer, please? Thank you, sir. Okay, Chairman to the front. Don't you know you're chairman? Okay. What's your bill number? Okay, go ahead. You have them turned on? Podium.
Wireless mic. Oh, the podium.
House Bill 789, creation of a surprise bill rating system. This is something that we've been working on for years. We have multiple pathways where we're trying to attack this problem. House Bill 789 is primarily to deal with the health benefit plans, insurance plans that have a network. That network currently will tell you, you can look up the specialist in it, you can look up a primary care doctor, you can find out what hospital's in it. One of the things you can't find out is those hidden doctors that I think are pretty important: emergency physicians, anesthesiologists, pathology, and radiology. Those are the ones where you don't know the name of your doctor, you don't get to choose them, you have no way to look up and tell whether they're in your network or not. And by the way, this is a network that you're paying $1,200 a month on average for a family health plan. So what it is, this bill would establish a surprise bill rating system that where we already tell the insurers how to list what hospitals are in network on their website, what doctors are in network, a way to look them up. At the bottom, it would have a surprise bill rating for those 4 that are typically hospital-based specialties, exclusive providers with the hospitals. It would give 4 green checks if all those are in network, and it would point out if those, if a particular health plan had somebody not in network.
Okay. He went over his time about a minute and a half. Are there any questions from anybody on the floor? Okay, seeing none.
Thank you, Mr. Chairman.
Sir. Representative Scoggins.
Thank you, Mr. Chair. I have for your consideration today House Bill 765. This is relating to courts in the code. This bill would actually increase the minimum compensation for magistrate judges, chief magistrate judges across the state. The code was changed in 2006, and they hadn't had a compensation salary raise since 2006, except for a few colors that they got along. This bill is the same or mirrors the exact bill that we did last year for the COAG constitutional officers. This is the same bill that we did for them and passed last year. The bill also sets the salary for associate magistrate judges, probate judges that also serve as magistrates, and for the clerks of magistrate court.
Okay. Any questions from anyone on the floor? Yes, sir. Need a...
They're the same as the constitutional officers were across the board, 5%.
So that answers my question. So
Yes,
I'm just looking at it real quick. The math was it's just a 5% increase across the.
It's across the board,
the,
5%. Yes, sir.
Okay. Chairman Fleming.
Judge, my question, I think, goes to what Chairman Martin was discussing, and sometimes when we look at the code section, we're updating these salaries, it looks like more than 5%.
Yes, sir.
It's because our code does not get adjusted when the COLAs
Right.
are adjusted, but it's really only 5%. Is that correct?
That is correct.
Any other questions?
But a COLA is an increase. It's
Yes,
real
sir.
money. And to quote our friends down in Columbus, like Aflac, it's real money.
Yes,
I mean, every Georgian doesn't get a COLA every year, and I understand the gentleman was kind enough, isn't it true, in our meeting earlier this morning to tell me this is county funds, but ultimately isn't also true that state sends a lot of money. So just as we grasp this, all the Georgians at the county level or the state level don't receive a COLA necessary. And so when we talk about they haven't had a raise, it's just a COLA. A COLA is a raise because they're
Absolutely.
doing the same job that the people that were paying them in the county are doing. I just want us to be thoughtful of the money, and it's not our money.
They went from 2009 to 2014 without any COLAs or any raise at all.
Are there any other questions? Representative Chairman Tankersley? No, hold on, y'all don't have to use a handheld.
Is it not true, Representative Coggins, that,
I can't hear.
okay, is it not true that this is usually a decision that's left up to local governments and historically or mostly done through local legislation?
The state sets minimum salaries for all constitutional officers and magistrate judges, and they have a choice whether to go with a local legislation which would set their salary, or they can choose to go with the state's minimum salary bill.
Thank you.
Okay, don't see any other hands. Thank you, sir.
Okay, thank you.
All right, anybody in the committee? Oh, Chairman Parrish over here.
Thank you, Mr. Chairman. I'd like to ask for House Bill 759. This is the annual drug update bill we do each year, and it just enables our law enforcement officials to do their job more effectively.
Okay, thank you, sir. Any questions? Hear none. Chairman Tanner.
Thank you, Mr. Chairman. Just want to ask for House Bill 820, the last on your list. Again, this is a result of the Freight Logistics Commission recommendation for a programmed area within the GDOT's budget.
Okay. Any questions? Hearing none. Okay. Representative Williamson? Don't use that. It don't work.
Thank you, Mr. Chairman. Members of the committee, I'm asking for House Bill 781, this is Department of Banking and Finance's annual housekeeping bill.
Okay. All right, let's see. Chairman Benton?
Hey, Mr. Chairman, House Bill 195, first bill on the list, Georgia Firefighters Pension Fund, we would increase benefits from $5,000 to $10,000.
Okay. All right. Representative Jones. Floor is yours.
Chairman Smith, thank you. Members of the committee, I am here this morning to present to you HB 538. I started my comments to the Judiciary Committee with the following. This is not a simple bill. We don't hear that often down here, and in fact it's not. And one of the things that was unique about this bill was that there wasn't a member of the committee that had ever actually had to present to a judge and actually present under the guise of having to deal with Chevron deference, or effectively what the deference means is inside of a tax tribunal or inside of the Superior Court, there's basically a two-pronged test. And this two-pronged test today is as follows. If the judge believes the statute is clear, we never make it to the second prong. At that point, then, it's game on. Basically, the plaintiff and the defendant, or in this case, the respondent, etc., they basically make their case to the judge, and the judge is able to make their decision. However, if the first prong is effectively that the judge determines that the statute is unclear or ambiguous, we move to the second prong. Today, the judge then looks at Did the DOR, and in this case this is restricted just to the Department of Revenue because we're dealing with the tax tribunal, did the DOR make an interpretation of this statute? And if they did, if the judge deems it reasonable, not the best argument, but reasonable, he or she must defer to the DOR, even if the individual or the corporation bringing their case, if he or she believes that their argument is better. This is fundamentally unfair. I believe our taxpayers, may they be an individual or may they be a corporation, they step into a tribunal, they step into a court expecting a judge not to be handcuffed. And in that case, the judge should have the opportunity to do two things. One, look to see did the DOR in fact make an interpretation, obviously review that interpretation, and then obviously listen to what the taxpayers' lawyers are saying in terms of their interpretation. We should free up the judges to make the decision in terms of what's in the best interest of the taxpayer and what's the best interpretation as opposed to merely deferring to a reasonable interpretation.
Okay, Chairman Fleming.
Thank you, Mr. Chairman. Representative Jones, is what you just said that when a judge is considering a regulation made by the Department of Revenue, they have to defer to what the legislature meant, not what the department interpreted? Is that right?
Actually, it's slightly. Right now, it's looking at what the statute says, determining if it's ambiguous, and then looking to see did the department in fact make an interpretation, and then reviewing that interpretation strictly on its face for its reasonableness. And if it is reasonable, today they must defer to that.
For example, if this had been in place when a judge, for example, may have been, I don't know, interpreting what a gas tax cut did or did not do, he'd have had to look more to what we did in the legislature than maybe what the Department of Revenue thought?
Correct. And I would suspect the taxpayer would say the same thing.
Okay. Chairman Martin.
So thank you, gentlemen, for bringing the legislation. So to go further with that, the tax tribunal is not attached to the executive branch. It's an appointed position. And for the most part, it handles matters for the Department of Revenue, which is also an executive branch agency. So without your legislation, we have an executive branch agency interpreting a statute, making a rule, taking it before a judge appointed by the executive branch, when a judgment against the Department of Revenue would be against the executive branch. So what we're doing here is giving that individual, even though it still may be slanted toward the executive branch, we're at least giving the taxpayer an even footing to play on. Isn't that what you're trying to get at in here?
Chairman Martin, right there is exactly it.
If I may, just an extension on this, isn't it also true that one of the tough things in this current situation is the next level of appeal from the tax tribunal is to the Superior Court? Is that not true?
That is correct.
Isn't it true that the Superior Court, as a general rule, isn't an appellate court? And I believe that's a true statement. And I want to go further with that and say that I am familiar with cases where Superior Court judges have said, I'm not an appellate court, I'm not getting into this business. You may be right, you may be wrong. Are you also aware of cases like that?
I've heard of them, yes, sir.
And isn't it further true that when that happens, an appeal to the Georgia Court of Appeals is a discretionary appeal? So without this legislation, the taxpayer may not ever get a bite at the apple for an appeal of a judgment off of an interpretation strictly made by the Department of Revenue.
Chairman Martin, I think that's a fair interpretation.
I hope the gentleman, as he goes through, maybe since the learned attorney there and the gentleman for side, maybe bring something forward that would allow an appeal from the tax tribunal, if it is heard by the Supreme Court, to have, I don't know the term, but a non-discretionary bite at the appellate court apple, so at least they get a true appellate court look at a decision. Thank you for bringing the measure.
Thank you.
Any other questions? Hear none. Thank you, sir.
All right. Thank you, Chairman Smith.
Well, I guess now is the time to set the calendar for the next legislative day, which will be day 13. And nothing official yet. I don't know when day 13 is going to be here. That's right. We'll have plenty of time to take a look at it. Okay, day 13. House Bill 781. Any opposition? Hearing none, it's on the calendar. 765. Okay. Any opposition? Hearing none, it's on the calendar. 759. All right. No opposition, it's on the calendar. 195. Okay. It's on. Any opposition? Hearing none, it's on the calendar. 538. Just wanted to see if y'all were paying attention. Okay. Hearing no opposition, it's on the calendar. That is the calendar for day 13. Thank y'all. Hey, you know, people even laugh at my jokes now.